Hi folks, and welcome back to Contract Law. This is video 5 in the video series on discharges of contracts. And in video 1 we laid foundations, in video 2 we looked at performance, in video 3 we looked at agreement, in video 4 we started our exploration of frustration, and in video 5 now we'll finish our exploration of the topic of frustration. And if you recall, we just finished the issue of delay, and now we need to look at illegality. Illegality is another issue that often crops up where parties argue that the contract has been frustrated by some supervening change in the law. And these cases, again, give you a good idea of when the doctrine will cut in and when it won't. In Scanlon's New Neon, you had TUI's agreeing to lease a neon sign, but unfortunately for them, this was during the Second World War, and there had been legislation prohibiting the illumination of such signs, obviously because of the bombing risk. So TUI's argued that the contract had been frustrated. There, it was held there was no frustration, as the sign still had some benefit for TUI's during the daytime. You could still see the word, and it still had advertising value. So there was another argument there of an implied term that the sign could be eliminated, but that also failed. So in that case, something similar to the Herne Bay case that we just looked at for the issue of failure of the basis of the contract, where they could still cruise around and look at the naval fleet. Here, TUI's could still use the sign as an advertisement during the day. It still had some value, so no frustration there, no radical difference. Metropolitan Water Board and Dick Kerr and Company case was a First World War case. There was frustration in that case. There was an agreement to build a reservoir, and unfortunately there was some legislation passed whereby the construction work needed to stop because the labour force needed to be used for the war effort. Because something similar to Cadelpha, because there was a fairly strict time frame in terms of getting this reservoir built, and the significant delays in having the labour force working elsewhere, it was held that the supervening change in law did frustrate the contract. Chazannikov and Roland Pex was a case for the sale and purchase of some beet sugar, and unfortunately there was some legislation passed that banned the sale of sugar. So again, the contract frustrated. So that's the issue of frustration for a supervening change in law. Land is a tricky one, and the doctrine of frustration fairly rarely applies to contracts for either sale or lease of land, and that's really because, particularly for contracts of the sale of land, the purchaser gets an equitable interest in that land pretty much as soon as they sign that contract, so they impliedly take the risk of something going wrong. It's expected that purchasers in that situation would take out a contract of insurance on the property that they just purchased to safeguard against anything terrible happening to whatever it was they just purchased. So it's usually thought that it's only extreme and very radical change, for example, complete resumption of the land or some kind of landslide or something like that, that might trigger off the doctrine here. But something like a house burning down, destruction of the property, they are things that are considered to be within the purchaser's risk, and the purchaser should have covered themselves for the eventuality of that risk. Leases, an agreement to lease confers an equitable interest in the property, and an actual grant of lease confers a legal interest to the lessee. There is a similar doubt about whether the doctrine of frustration can apply here. The consensus is that it will hardly ever apply. The National Carriers case is kind of the paradigm case here. So there was a 10-year lease of a building, and 5 years into the lease, the council closed the only road access to the premises. Unsurprisingly, the tenant stopped paying rent, and the landlord ended up suing for back payment of the rent. the tenant argued frustration. The closure was originally anticipated to be around a year or well over a year. The actual closure ended up being for 20 months, so almost 2 years of a 10-year lease. In that circumstance, the court held no frustration, given that there was still another 3 odd years of the lease to run. The tenant could still get the substantial benefit from the lease, so no frustration there. As I said, hardly ever will apply here. Obviously, because the doctrine of frustration is a bit of a get-out-of-jail-free card for some, it has its limits. And these are the limits that you need to watch out for. Where there is an express contract term that deals with the supervening event, that is going to prevail. So in the Claude and Hardy case, again, something similar to Scanlon's new neon and Twiz case, a contract to hire a neon sign. Here, there was a clause that allowed the plaintiff to claim the entire unpaid balance of the hire if the lessee's interest was somehow extinguished or transferred. In fact, the premises were resumed and the interest in the premises was extinguished or transferred, so the plaintiff claimed the money. It was held, obviously, the contract was not frustrated and the contract term prevailed. Force majeure clauses. Now, we could have a whole video on force majeure clauses. Try saying that underwater with a mouthful of marbles. But these are just clauses that stipulate the consequences for certain events happening. They're very common in longer contracts and building and construction contracts. So it's just, a way that the parties try and get around the doctrine almost. These clauses are interpreted very strictly, contra proferentum. Won't necessarily always oust the doctrine. It's really going to be a matter of the court interpreting the clause and asking itself whether or not the parties intended that clause only to govern the event that has actually occurred. And I have given you an example there of a force majeure clause. They're usually very long. Some run into many numbers of pages. And as I said, we could talk forever about force majeure clauses, but for our purposes here, you just need to know that if the parties have said something in the contract about the way things should go down if one of these frustrating events happen, then that's probably going to rule the day. What happens if the supervening event was not provided for in the contract but was actually foreseeable? You need to ask, when you're assessing the radical difference, what the parties actually contemplated. Now, here there is a difference between the parties actually assuming the risk of something happening, the risk of a supervening event happening, and it's just being foreseeable. If there is a serious possibility that the event might have happened, then you might find the doctrine of frustration doesn't apply. And in the Tatum and Gamboa case during the Spanish Civil War, another shipping case, there was a charter party for 1 month. The parties knew that the ship might be seized, obviously, because it was a circumstance of war. If you're sailing around, there's a risk of being seized. And so the parties had catered for that by paying around 3 times the going rate for that kind of charter party. The ship was seized. It was detained for 2 months. Now, that was far in excess of what anyone thought a ship could be seized for back in the day. So whilst the event had been contemplated, the severity of the event had not been contemplated. And so the contract was still frustrated. The price wasn't payable. The Morton Harvey case is a nice little contrast to Tatum and Gamboa. In that case, no frustration because the event was foreseeable. In that case, you had the owner of a hotel that knew that there was a real risk that the hotel was going to be resumed and demolished. And despite all of that, they decided to enter into a contract for a term of years with a party to actually erect an advertising sign on the hotel. Partway into the contract, you guessed it, the hotel was resumed and the advertising sign was taken down. The plaintiff sued for damages because their sign had been taken down, and the defendant said, sorry, the contract's been frustrated by the resumption. There was held, obviously, no frustration there. The precise risk that had been very clearly apparent prior to the contract had eventuated, and in that case, foreseeability prevented the doctrine of frustration from saving the day. So that's the issue of foreseeability. Self-induced frustration is another limitation on the doctrine of frustration. And as you'll remember, the test for frustration is that there must be no default by either party. So if the frustration is self-induced, especially because of negligence, then the party that's at fault won't be able to rely on the doctrine of frustration to get them out of trouble. And that includes where a party has a choice as to whether to fulfil their obligations or not, and chooses not to. They can't then fall back on arguments of frustration. The Maritime National Fish case is the classic case of self-induced frustration, and in that case you had Maritime National Fish chartering a trawler from Ocean Trawlers. It had chartered a number of trawlers, and all of the trawlers required appropriate licensing because they operated, I think they were called otter trawlers. In any event, they needed appropriate approvals. Maritime applied for all of the approvals that they needed, the licenses they needed. They applied for 5 licenses, they only got 3. And so they said to Ocean Trawlers, sorry, contract's been frustrated, we haven't got enough licenses, and you're the one that we're nominating not to, your trawler is the one that we're nominating not to need because we have no license for it. In those circumstances, it had been their choice not to honour the contract. It wasn't a supervening event. It was not induced by their own behaviour, so no frustration coming to the rescue there. So that is self-induced frustration. The last thing we need to talk about is the effect of frustration. And it's kind of unique amongst the various different ways to discharge a contract, because a conclusion that a contract has been frustrated means that at the point in time of the supervening event that causes the frustration, at the time that occurs, the contract is automatically discharged. Automatically. So no one needs to do anything. That's just what happens. Both parties are released from further performance. There's no need to make any election to terminate or anything like that. We'll be talking about that in an upcoming video. It's not void ab initio. So when the frustrating event occurs, the contract has ticked over perfectly fine up until then. All of that contract that has been on foot stays on foot. It's only cut off, discharged from the supervening event and for the future. That has some significant consequences. It means that rights that have accrued prior to the frustrating event are unaffected. So if the right to payment, an instalment or some kind of other, important right like that has accrued prior to the frustrating event, then the party still has to perform. You'll find that rights are only unenforceable if there has been some kind of total failure of consideration. And we'll cover total failure of consideration in more detail when we look at remedies. But essentially what it means is that if a contract has been frustrated, the loss will lie where it's fallen. So in Re Continental Rubber, you had Continental engaging a company called Anderson's to construct and install some machinery on its land. Partway through the contract, which had provided full progress payments, so Continental had been paying diligently in expectation of eventually receiving this machinery. Partway through the contract, the First World War broke out, and the company, Anderson's, because it was controlled by enemy aliens, was placed under a court-appointed controller, and then after the war, the Anderson's company was actually wound up. So Continental never got their machinery, and unfortunately they paid over these progress payments. Anderson's sought payment of the rest of the contract price, Continental, not surprisingly, sought either the return of its progress payments or delivery of the machinery. The court held that the contract had been frustrated by the outbreak of war, and unfortunately for Continental, they couldn't recover the payments that they had already made because they had fallen due legitimately under the contract before it had been frustrated. And they couldn't demand delivery of machinery because the contract had just been frustrated, discharged. But also, Anderson's couldn't claim payment for the rest of the contract price. So you can see this result of the loss lying where it falls can produce some fairly unfair results. That's where we then have the Fibrosa case, which deals with total failure of consideration. In the Fibrosa case, we had Fibrosa, a Polish company, contracting with Fairbairn, an English company, to buy some machinery. The all-up price was £4,800, of which Fibrosa had paid £1,000. Unfortunately, Germany invaded Poland, and that contract was frustrated. And that contract, being quite similar in some ways to Continental, is a good revisitation of the results of Continental. The Fibrosa case was fought all the way up to the House of Lords, and in the House of Lords it was held that where you have a contract like this that's been frustrated, then if there has been a total failure of consideration, that is, you have received no part at all of what you've contracted for, then you may be able to reclaim the monies that have been paid over under a frustrated contract. So in that case, Fibrosa was able to recover its £1,000 from the English company Fairbairn. I guess it accords with our feeling of equity and fairness. We are yet to have a definitive call on this in Australia, but there are certainly indications by the High Court that they would consider Fibrosa to be the correct exposition of the law in Australia. So I guess the takeaway message is that where a contract has been frustrated, generally speaking, unfortunately, the loss will lie where it's fallen. The only exception will be something as narrow as the Fibrosa case. If there's been a total failure of consideration, then you might find you are able to recover some of what you've paid over or all of what you've paid over. If there's no total failure of consideration, then you're not going to be able to recover payments that are made under a frustrated contract. Contrast, just a bookmark for future reference, contrast the issue of where services are provided after frustration. So the parties have been operating in a contract quite happily, the contract's been frustrated, but for one reason or another, the parties keep providing the services that they've contracted to provide. Now, in that circumstance, you are going to be seeking a fair compensation for the work that's been done, and that is where the doctrine of quantum merit comes in. We'll be looking at that, as I said, in the remedies video series later on. So that is the effect of frustration at common law. It might ease your consciences to know that there are some jurisdictions in Australia that have legislated to mitigate the sometimes harsh effects of the consequences of frustration. Those jurisdictions in New South Wales, Victoria and South Australia. I'll leave you to flesh out that in the text, paddle about in the readings for that one, but that is the issue of frustration. And so now we come to the final aspect of discharge of a contract, and that is discharge by termination. But I will move across to video 6 now. So until then, folks, bye for now.